You're trying to find an attorney to help you solve your medical malpractice matter. I want to share with you today one question that you should ask every attorney you are considering to determine how much leverage this lawyer is going to have when he begins negotiating your case with the doctor's insurance company. Come join me for a moment as I share with you exactly what this question is. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, let's say you believe your doctor was careless and his carelessness was a cause of your injury and that your injuries are significant and permanent. And now you believe you have a valid case, but in order to know for sure, you now go searching for the best lawyer to help you solve your legal problem. But the problem is, you don't know which lawyer is right for you. So you begin your search. You go online to help you understand how your type of case works. Now you narrow down your search to a handful of lawyers. And I want to share with you one important question that you should be asking each and every one of these lawyers to determine whether this lawyer is right for you. And what's that question? Here's the question. How many times have you gone to trial in the past? In the past year, in the past 5 years, in the past 10 years? That's the question you need to ask each and every one of these attorneys. Now, why is that important? It's important because when you bring a lawsuit seeking compensation, seeking money as a form of compensation for all of the harms and injuries and damages that you suffered because of your doctor's carelessness, well, guess what? The insurance company is not going to be afraid of you. They're not going to be afraid of the attorney. Unless your attorney has a track record of going to trial and getting verdicts in favor of the injured patient. That's when the insurance company sits up and takes notice. And they say, hey, this lawyer is not afraid to go to trial. This lawyer is not afraid of our negotiating tactics. This lawyer is not afraid to go ahead and take a verdict. In that instance, a lawyer who has a history, a track record of going to trial and taking verdicts and getting them sustained on appeal, meaning that they are upheld on appeal, now the defense knows, they know, hey, listen, this attorney isn't afraid. So now if he's looking to try and settle this case, in the event he's not able to negotiate the case, then the defense and the insurance company know, guess what? He's going to take a verdict. He's not going to shy away. He's not going to simply take a lowball offer from the insurance company. An attorney who is not afraid to use his resources to go all the way to trial if he has to, and to go to verdict. Now he can leverage his knowledge, his experience, against the insurance company, against the doctor, against the doctor's attorney. And now he say, listen, if you guys don't want to come up with a reasonable and appropriate settlement, hey, we'll see you at trial. We'll go to trial. The jury will come back with a verdict, and in all likelihood, it'll be much more significant than what you're willing to negotiate for. That's the way to get leverage. And in that instance, there is the possibility that the insurance company will say, you know what? We don't want to go to trial. We don't want to go the distance, because we know, or there's a good likelihood that if we get to that point, the jury will come back with a more significant number, a significant value, compared to trying to negotiate and settle this case out of court for a lower amount of money. So that one question alone will help you understand whether or not this attorney is likely going to have greater leverage when negotiating with the doctor's insurance company compared to someone who doesn't go to trial at all, or someone who goes to trial infrequently. As you are searching for the right attorney for you to solve your medical malpractice problem, make sure you ask each and every attorney you're considering, how many cases have you tried in the last year, in the last 5 years, in the last 10 years? And then, you know what, you should also ask, have you ever lost a case? Have you ever lost a case at trial? Most attorneys in their marketing messages, they never ever talk about the cases that they lost. Why not? Because they fear that if they talk publicly about the cases that they lost, prospective clients will not want to hire them. But you should know something. It's often important to understand why an attorney lost a case. It may not be the attorney's fault. Maybe the jury didn't like the client. Maybe the jury didn't like the facts. Maybe there was something in the case the jury didn't like, and it had nothing to do with the attorney and his abilities. And so you'll find that some of the very best attorneys do, in fact, talk about the very few cases that they've lost. In that instance, you begin to say, hey, now I understand. Now, maybe this attorney is right for me. So why do I share this great information with you? I share it with you just to give you a sense of exactly what goes on in these medical malpractice cases here in New York. You know, I do recognize and I do understand you're watching this video because you likely have questions about your matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.